Once laws are passed by the legislature and regulations are promulgated within administrative agencies, disputes arise over whether the regulation represents the intent, and what compliance looks like. U.S. litigation is the use of adversarial dispute resolution to interpret and enforce laws. Frequently litigation and a path through the judicial system is the way implementation of environmental laws is refined, over a larger scale of time. At a smaller scale, litigation is just one path toward resolution of individual disputes. In this chapter you will explore the litigation process and other tools for resolving environmental disputes. Based on your study of Chapter 2, you should be able to define the adversarial system and explain its implications for how disputes are resolved in court. Describe the U.S. court system. List and define threshold issues necessary to instigate litigation. Outline the process of civil litigation. Explore how two alternatives of litigation, arbitration and mediation, might serve to resolve many environmental disputes better than litigation. Our adversarial system is defined by three things: a neutral or unbiased judge, opposing sides, and evidence-based arguments presented by the opposing sides. There are also strict rules that govern the process by which a decision is reached. The system is carried out through the U.S. courts. Advocates of use of this system argue it is the best way to find the truth. Each side is motivated to aggressively seek evidence to support their position. Both sides argue aggressively and seek to identify flaws in the arguments of the opposition. Thus, with this level of evidence-based scrutiny, the truth should be apparent. In contrast, critics of this approach to the judicial process are quick to point out evidence discovered by one side that is helpful to their adversary, even if valid, will not be presented. Also, since the outcome of the process is highly dependent on the quality of the attorney representing a given side, it is reasonable to expect that the most skillful attorneys will charge higher fees. Thus the wealthier party has a huge advantage. Both of the aforementioned problems could result in biased outcomes. Additionally, the adversary system seeks to reward a singular winner, when the most beneficial answer may be a compromise. When considering the use of the adversarial system for environmental cases, these criticisms can be really important. For example, a member of the public who sues a company for their impact on his property or his health is not likely to secure equal or superior legal assistance. In fact, a common tactic for corporations in lawsuits is to set up many pre-trial motions in order to drive up the legal costs for the plaintiff. In this way, they both stall the process and also can cause the plaintiff to drop the suit because they cannot afford to see it through. Furthermore, in environmental cases, finding a winner does not necessarily breed a sense of cooperation among parties, who may very well need to continue interacting or coexisting in the same community. Ideally, environmental disputes would involve creative compromises. Again, the U.S. judiciary is based on the adversarial system. As we learned in Chapter 1, under federalism we have dual sovereigns. Not surprisingly, we have a dual court system, inclusive of both federal and state courts. Figure 2.1 in the book shows these dual systems. Federal court system. Jurisdiction is the power of a court to hear a case and render a decision. The trial court is the court of original jurisdiction, which means the court has the authority to hear and decide the case first. The federal courts of original jurisdiction are the district courts. The U.S. has 94 districts with set boundaries and at least one trial court per district, and at least one district per state. The second level of courts in the federal system is made up of the U.S. Circuit Courts of Appeals. The United States is divided into 12 geographic areas, including the District of Columbia, each of which has a Circuit Court of Appeals. There are also federal Circuit Courts of Appeals. Each Circuit Court of Appeals hears appeals from all the district courts located within its area. Appeals from administrative agencies are heard by the Federal Circuit Court of Appeals. Court of last resort. The U.S. Supreme Court is the final appellate court in the federal system. In some instances, the Supreme Court also hears cases from the court of last resort in a state system. The Supreme Court may also function as a trial court in an extremely limited number of cases, such as suits against ambassadors of foreign nations. The state court systems. There is no uniform state court structure because each state has devised its own court system. However, all states follow a general structure similar to that of the federal court system. In state court systems, trial courts, or courts of original jurisdiction, are distributed throughout the state, usually by county. Cases involving state environmental laws will generally be brought in the state trial courts of general jurisdiction. Also, private tort claims involving environmental matters are usually brought to these courts. Intermediate courts of appeals, similar to the federal circuit courts of appeals, exist in approximately half the states. These courts usually have broad jurisdiction, hearing appeals from courts of general and limited jurisdiction as well as from state administrative agencies. The names of these courts often vary by state. They may be called courts of appeals or superior courts. In almost all cases filed in the state court system, the last appeal is to the state court of last resort. This court is frequently called the state Supreme Court. In some states, it is known as the Court of Appeals. In almost half the states, this is the second court to which an appeal can be made. In the other half, it is the only appellate court, homologous to the authorities granted to the federal and state governments under federalism. The state and federal courts have either distinct or concurrent jurisdiction depending on the subject matter in question. The state court system has jurisdiction over all cases not within the exclusive jurisdiction of the federal court system. Because the federal courts have exclusive jurisdiction over very few issues, it is no surprise that most litigation occurs in the state system. Cases falling within the exclusive jurisdiction of the federal courts are listed Figure 2.3. If these cases were tried in a state court, any decision rendered by the judge would be void. Cases that fall within the exclusive jurisdiction of the federal courts include such matters as admiralty, bankruptcy, federal criminal prosecutions, claims against the United States, and claims arising under those federal statutes that include a provision for exclusive federal jurisdiction. Cases brought under such statutes must be filed in the federal district court or the appropriate federal court of limited jurisdiction. Thus, whenever an action based on a federal statute is anticipated, the statute should be read carefully to discern whether cases under the statute fall within the exclusive jurisdiction of the federal system. Many federal environmental statutes grant exclusive jurisdiction to the federal courts. Many cases have concurrent jurisdiction, thus they may be heard in either the federal or the state court. The plaintiff may file in the trial court of either system. There are two types of concurrent jurisdiction cases. The first are federal question cases. If a case requires an interpretation of the U.S. Constitution, a federal statute, or a federal treaty, it is said to involve a federal question and may be heard in either state or federal court, because most federal statutes do not grant exclusive jurisdiction to the federal courts. Thus, if a specific federal environmental statute does not grant exclusive jurisdiction to the federal system, it falls under concurrent jurisdiction. The second type of concurrent jurisdiction case involves diversity of citizenship. When the opponents in a case are from different states, diversity of citizenship occurs. The diversity must be complete. If any two parties on the opposing sides reside in the same state, diversity is lost. For example, if the plaintiff is an Ohio resident and one of the defendants lives in Michigan and the other in Indiana, diversity exists. However, if an Ohio plaintiff is bringing an action against a Michigan defendant and an Ohio defendant, there is not complete diversity and, therefore, no concurrent federal jurisdiction. Also, when the basis for federal jurisdiction is diversity of citizenship, the controversy must involve at least $75,000. When a case falls within the federal court's concurrent jurisdiction because of either a federal question or a diversity of citizenship, the suit may be filed in either state or federal court. If the case is filed in state court, the defendant has a right of removal, which means that he or she may have the case transferred to federal court. If the plaintiff files in federal court, the case must be heard in that court. Why should both parties have the right to have such a case heard in federal court? In certain cases, a party may fear local prejudice in a state court. Juries for a state court are generally drawn from the county in which the court is located. The juries for federal district courts are drawn from the entire district, which encompasses many counties. Juries in state courts are, therefore, usually more homogeneous than those in district courts. One problem that this homogeneity may present to the out-of-state corporate defendant occurs when the county in which the court is located is predominantly rural. If the case involves an injury to a member of this rural community, the defendant may feel that the jurors would be more sympathetic to the local injured party, whereas jurors drawn from a broader area, including cities, may be more likely to view the victim less sympathetically. City residents are more likely to work for a corporation and, thus, may not regard corporations as unfavorably as rural residents might. Some people believe that because federal judges have more experience in resolving questions that require an interpretation of federal statutes, they are better qualified to hear such cases. Finally, if a party anticipates that it may be necessary to appeal the case to the U.S. Supreme Court, bringing the case in a federal district court first may save one step in the appeals process. In everyday life, if you discuss venue, you are referring to a place to hold a celebration, see a performance, or watch a game. In legal terms, venue is something else. Once the court system appropriate for the subject matter is established, then there is the separate question of venue. Venue refers to which court within the system is appropriate. Venue refers to geographic location, and it is defined within a statute for each state. Usually venue is based on residence of the defendant, location of the property in dispute, or the location in which the incident of dispute occurred. If there are multiple defendants, then the plaintiff may choose among the venue options to include the various defendant residents and the site of the dispute. When a corporation is a defendant, their residence usually refers to the location of the corporate headquarters. If the location of the court in which a case is filed represents a hardship or inconvenience to one of the parties, they can request a change of venue, and motion may or may not be granted by the judge. Each party may be represented by an attorney who is qualified by the state in which they practice. Attorneys can provide full-time in-house counsel to firms, represent a party in court litigation or before other boards, negotiate contract terms, provide counsel or advice, or draft legal documents. Attorneys require all client information to work, but this privilege comes with the assurance of attorney-client confidence. Legal permission is required to disclose confidential information. This protection extends to legal documents prepared by the attorney. A judge's role depends on whether they serve in a trial or appellate court. In a trial court, the judge hears cases, rules on motions, and decides on questions of law. They also explain jury instructions, keep up a trial pace, and make decisions when parties waive certain rights. Such responsibilities grant judges a great deal of discretion, and allow decisions to be influenced by ideologies and education. Thus, litigants should try to know about the judge's ideology before bringing a case to trial. Courts can earn pro-environmental or anti-environmental reputations. These reputations influence the types of cases brought to them. The decisions handed down by courts can change with the makeup of the court changes through retirements, resignations, and new appointments. In an appellate court, the judge serves on a panel of at least 3 people. They review cases appealed from lower courts, read over argument transcripts, and hear oral arguments. The jury is a group of randomly selected people from the same geographic area as the court, allowing for citizen participation in judicial processes. The job of a jury is to decide questions of fact, rather than questions of law. Petit juries are used in trial courts. They may have 12 or fewer members and may allow non-unanimous decisions. In civil cases, the plaintiff must request a jury, but both parties may agree to waive the right to a jury. If equitable remedies, specific performance, injunctions, or rescissions are sought, then no jury is allowed. Grand juries are only used, and required by the Fifth Amendment, in criminal cases. They are to initiate an indictment for federal prosecutions, evaluate the prosecutor's evidence, and determine whether the defendant may be charged. Threshold requirements ensure that only cases that truly require adjudication and that both sides are represented in court. These requirements are standing, case or controversy, and ripeness. Standing is the legal right to bring a lawsuit. It authorizes a proper party to pursue the action if they have a stake in the outcome and if the controversy can be addressed or resolved by the courts. Standing is clear in cases where individuals who are personally affected by the outcome of a case. There is some controversy over whether environmental groups have sufficient standing to bring an environmental case. Does the Sierra Club have standing to file a suit to get an injunction against building a dam? Some might say if there are no specific members in the Sierra Club cited who have property directly impacted by the dam construction, then the Sierra Club does not have sufficient standing by representing U.S. citizens who want to preserve nature. Case or controversy requires that interpretations vary. This means that the parties oppose one another, events lead to a legal dispute, and the courts can give an effective decision. In other words, a problem must exist that the courts can solve. Ripeness means that the controversy is immediate, and that a decision will impact the parties in the present or near future. A controversy is moot and non-justiciable when it is no longer ripe. Figure 2.4 from your book shows the steps in the civil litigation process. The rules that govern these proceedings are called the rules of civil procedure. It is worth noting that the procedures in civil and criminal cases are quite similar, with the exception of the pretrial release of the defendant and sentencing aspects of criminal cases. Before the trial begins, an attorney must be approached with all relevant client information. If an informal resolution cannot be sought, pleadings are filed and served. Pleadings are the legal papers that include complaints, answers, counterclaims, and motions to dismiss. When the complaint is filed by the plaintiff, the court serves the complaint to and summons the defendant. This provides notice of pending legal action and authorizes court jurisdiction over the defendant. As mentioned before, jurisdiction is based on residence in that state or by minimum contacts with that state, by property within state borders, and by subject matter. Service, or delivery, can be through a person, resident, certified mail, or corporation agents. The defendant can respond to being served by filing an answer and a counterclaim. They can deny, affirm, or counter plaintiff allegations, but if they do nothing, then their answer is considered a default. If they file a counterclaim, the plaintiff must file an answer in response. After pleadings are filed, pretrial motions may be filed. Motions may call for the case to be dismissed. A summary judgment may also be requested if there is no disagreement on facts and the filer or mover wants to win the case based on only a question of law, but this rarely happens. After pleadings and pretrial motions, discovery occurs. Discovery is the search for relevant information from the opposing party. Its purpose is to obtain and preserve information, avoid surprises in court, and narrow down relevant facts. One method is interrogation, which uses written questions that must be answered truthfully by the parties. Depositions are sworn testimonies and answers from either side, used when witnesses will not be in court or try to change their testimony. There may also be requests for admission to facts, documents and tangible items, or to physical and mental examinations whenever they are relevant to the case. If there is indeed a question of fact, a pretrial conference is used to try to settle or plan how to conduct the trial. Only the attorneys and judge are present at this meeting. A trial begins with the selection of a randomly assembled citizen jury, unless equitable, non-monetary compensation is being sought or if the right to a jury is waived. The process of voir dire determines whether candidates will be unbiased in their decision-making. This is a difficult process and can be quite expensive. A limited number of rejections of jurors without cause may be used by each side, called peremptory challenges. If a reason or cause is given, however, each side's attorney may reject an unlimited number of candidates. One or both litigants may also hire a shadow jury. Members of the shadow jury are selected to mirror the makeup of the true jury. The shadow jury sits in on the trial, and each day they discuss what happened. This discussion is usually facilitated by a legal consultant hired by the litigant sponsoring the shadow jury. These discussions are used to inform that legal team about what aspects of their case are and are not playing in their favor. Thus they can adjust their approach over time, and also presumably better predict the verdict. The case begins with opening statements. Each side speaks to the judge and jury. The statement outlines facts and the implications of those facts and sets forth their position on how the case should be decided. The plaintiff is the person files the complaint that brings about the lawsuit. The plaintiff presents their case first, during which they provide evidence and examine witnesses. Witnesses are directly questioned and then may be cross-examined by the defendant's attorney. The plaintiff can respond to a cross-examination with a redirect examination, at which point the witness may also be re-cross-examined. After the plaintiff's case, the defendant may move for a directed verdict, stating that there was not evidence provided to support the plaintiff's claim. Otherwise, the defendant presents his case. Witnesses and direct and cross-examination practices are true here as well. At completion of the defendant's case, a directed verdict motion can be requested as well. Once both cases are rested, the attorneys and the judge hold a conference to discuss the instructions to the jury. Each attorney requests wording that favors their client. The judge decides on the final wording. There are closing arguments to summarize facts and claims. In closing arguments, the one with the burden of proof The plaintiff goes first, and the defendant goes next. The plaintiff may have a rebuttal if they choose. The judges provides the instructions to the jury. The attorneys pay close attention to how the instructions are delivered because this can be an important part of the appeals process. Next, the jury deliberates to make a decision. Once the decision is made, the verdict is read in court. Post-trial, several motions may be made. A party may file an appeal for a new trial if there is a reason to start all over, if the verdict clearly does not reflect the evidence or if there was improper conduct or application of procedures. This new trial, if granted, will occur in the Court of Appeals. Alternatively, the losing party can request a judgment notwithstanding the verdict. In that instance, that party asks the judge to make a decision contrary to the jury because the jury was unreasonable or incorrect as a matter of law. A dissatisfied party may appeal the trial court decision. The filing party is called the appellant, and the opposing party is the appellee. Rules of filing must be followed, and the filing party must show that there was a prejudicial error of law. In other words, the trial court made a mistake that affected the outcome of the case. Appealed cases require effort and financial backing, but they may also have precedential value that surpasses trial court precedents. There is not a new trial in an appeal. Instead, each side files a brief, or written argument. The appellant explains why the previous decision was erroneous, and the appellee explains why it was correct. Oral arguments may also be made. The court reviews the briefs and oral arguments and comes to a decision. The court may reverse, affirm, or modify, by lowering damages, the prior decision. The majority opinion is explained and written by one of the judges who voted with the majority. Other judges may also write dissenting opinions or concurring opinions. There is no automatic right to appeal to a higher court, and a state Supreme Court decision is final unless a federal question is involved. Appeals to the U.S. Supreme Court may be by writ of certiorari or appealed as of right. The former states that a federal question or matter of conflicting appellate court decisions is involved. For a writ of certiorari appeal to be successful, at least 4 Supreme Court justices must agree that the case can and should be reviewed. An appeal as of right states that a party is entitled to an appeal, and once a notice is filed, the Supreme Court has to look at the case. It is usually not a privilege of a losing party to appeal by this method. Civil litigation requires time, effort, and quite a great deal of money. Alternatives to litigation are less expensive, follow less formal processes, and are more likely to result in a compromise than litigation. Another result of both of these alternatives is the lack of binding precedents or publicity. Environmental problems are often poorly suited for the adversarial nature of litigation, so these forms of conflict resolution are important complements to the court system. The two main alternatives in environmental law are arbitration and mediation. Arbitration resolves disputes using a neutral third-party judge, or arbitrator. This judge takes a more active role in proceedings, but as professionals they maintain a goal of being fair and factual. An added benefit is that the arbitrator typically is more knowledgeable and familiar with the case subject matter than a judge in a civil trial. Attorneys are not required in arbitration. The decision made by the arbitrator is legally binding and final. Parties agree to this prior to the arbitration. Thus, the decision cannot be appealed unless there was fraud or excessive liberty taken by the arbitrator. This method of dispute resolution can be sought by including a binding arbitration clause in a contract or by a submission agreement. Contracts and agreements require arbitration to be used if a dispute arises. Mediation also uses an uninvolved third party, and this mediator helps the disputing parties reach an agreement on their own. While solutions can be proposed and communication can be facilitated, the final decision is made by the opposing parties. Because of this, a solution can be reached very quickly and relationships are better preserved. This form of conflict resolution works for many cases of environmental problems. As with arbitration, however, mediation requires the participation of all interested parties.